Well, good morning. I'm Valerie Glenn. I'm the president of the Cranberry Country Chamber of Commerce. Today we have the Helene Horn Figman coming back. Welcome, Helene, to talk about Human Resources Law 101 for small and mid-sized businesses. Before I'm going to have Itamar introduce Helene. And Itamar, thank you for being the cohort and strategic partner in our seminar series. It's such a great benefit to our chamber members and those who join us. So does anybody know what tomorrow is? Special day. It's Support Your Local Chamber Day. Wow. National Support Your Local Chamber Day. So it's also the our membership campaign. And I wanted to say, for those who are not members yet, there are some great benefits to join and sign up to our Chamber of Commerce by October 31st. There's some discounts and there's some marketing benefits and all the usual benefits that you get from our chamber. So if you're thinking about joining and you haven't joined yet, do it now. This is the best time. Also for members who are already a member, help somebody else join, help somebody else get the benefits of the Chamber of Commerce. So many of our members are solopreneurs and have nobody to talk to, no way to get involved in networking. Our chamber provides opportunities for networking, opportunities like this this seminar for educational services and legislative advocacy. There are a lot of things that the chamber is backing right now that will be on the ballot for November 8th. And, you know, if you need some clarification on some of those things, please read your form that you've gotten in the mail, the red little booklet. It will explain both sides of each ballot issue. And that's what I wanted to say. So join today if you haven't joined yet. And Itamar, thank you for this. Pam, thank you for running the show. And why don't you introduce Helene to us?
Good morning, everybody. I'm not going to read Helene's bio because I don't want to waste your time. You already read it. But I can tell you that I've met Helene. Helene has a very unique background, just to the fact that she was a judge at the court against discrimination. And I met her shortly after she went back into private practice. So I think she brings a very unique perspective to her practice and to her customers by having been on the bench, seeing the cases from that other side. So she is much better in advising her customers than most other people in the industry, in my opinion. Today, we're going to do something a little bit different. I have a list of questions I'm going to ask Helene. Some of them based on my conversations with her in the past, some of them because I talk to my customers and I see where they're missing some information. So we're going to just get started. So Helene, thank you for coming today. Pleasure to have you.
Thank you so much. And I look forward to hearing your questions, and I'll come up with the best possible answers for all of our attendees today. Obviously, I can only give general answers and general advice. You know, the Mass Bar Association frowns on me giving specific client advice like this, but I'm happy to be of service. And if anybody wants to follow up with me, you know, at a later date, of course, for more specifics, that's certainly, they're welcome to do so. But let's get started today.
So let's start with something pretty simple. What is involved with hiring a new employee? Does an employer need to follow any particular rules, or just what do they have to do?
You know, hiring is a daunting task, and the preparation for employers, I think, is the key. Who are you hiring? What are your needs? People just think, oh, I better post, I'm short on staff, and they rush to judgment, they rush to put an ad in somewhere. So I would say that the first step is to take a broad picture of your company's needs. Where are you at now? Maybe 4 years ago, when the world was different, you were hiring some on-site receptionists, let's say. But in this world, maybe you have less people coming in the office, and maybe what you need is an extra pair of hands in the back room, in the inventory area. Can a phone be placed back there for your calls? And do you really need that receptionist? So think about what your needs are. In terms of the hiring process, you have to be careful about your ads, your postings. You don't want to have discriminatory ads. So nothing about mother's hours. That kind of went out in the 60s and 70s. Buzzwords like youthful energy. We're seeking a new type of youthful energy. Boy, that screams age bias to me. So you want to avoid any inflammatory, discriminatory, even subtle discriminatory wording in your postings and your ads. It's about protecting your business and you and doing the right thing. What else did I want to bring up about that? I had together some notes anticipating. Okay, so I wanted to talk about hiring in the broad sense of how the hiring process is handled. And that would be interviewing, right? How do you handle the interview? Well, again, not to be a broken record, but you don't want to ask discriminatory questions like, do you have sufficient childcare? That's against the rules, violative of Chapter 151B of Massachusetts laws. And so what you should be doing, and this is best practices for all HR people, and I know I see this like a few HR people on the screen, have the applicant have a copy of the job description. Have the interviewer have a copy of the job description, right? And what your key is to go through the essential functions. So when you're hiring, you want to make sure that you're really looking for someone who has the experience and background in the essential functions of the job. By having the job descriptions in front of both the applicant and the interviewer, you're ensuring that it's a uniform process. And it helps the interviewer because you don't go off the rails. And if you have an applicant that, and I help people with interviewing, I've recently been part of several interviews for clients. They bring me in as a kind of a clear head, objective. And I've seen a lot of applicants just totally go off the rails, and they're asked one thing. In fact, I asked one thing about, what they would do with a team that, is needing more mentoring and this, and they started answering about something totally different. So having kind of an outline of that job description keeps everybody on the same page. It also allows for uniformity. So you're not asking someone who's 65 different questions than you're asking someone who's 25. You're not asking women different questions than you're asking men. You all get the picture. We're looking at not being discriminatory, being uniform, and looking at what your needs are. So the hiring process, in terms of posting, be careful about discrimination. In terms of interviewing, be careful about discrimination, and really look at corporate needs. What are your legitimate needs? Spend your money in the right place.
Thank you. I know that the law treats different businesses by the number of employees differently. What happens when you have a smaller business, let's say 12 employees or less? Do they have to have a job description? Does they have to have handbooks? Smaller business, usually people know what they're doing anyway.
Right. We assume that if we have 10 employees, everybody knows what their job is. So why bother with a job description? I get a lot of snickers when I work with my smaller employers, and I have indeed some really small employers. But it is important to have the job description, and it's not silly, and not everybody does know their job. It's interesting because I've looked at job descriptions for many of my employer clients from maybe 2016. And then I look at what they're telling me they're looking to hire. And I said, wow, you've really changed that job. Or else one of them isn't accurate. The one you had in 2016 doesn't accurately reflect what you were looking for. And they're like, oh, wait a minute. We don't want that person doing this. We have somebody in the operations team doing that. What was I thinking? Yeah, why is that in there? And then I'm saying, well, why is there a driver's license in this one? Are they driving for your business? It just should be, can they get to the workplace? Do they have means of getting to the workplace? And they're like, oh yeah, that role doesn't need a driver's license. So job descriptions, really accurate ones, are a tremendous benefit. In fact, it is my #1 HR best practices tool, bar none. Policies, handbooks, performance reviews, job descriptions are crucial. And why do I feel that way? Well, one is because of the outside world feels that way. So workers' comp insurance companies, if someone has an accident and they're saying they can't do their job functions, what do you think everybody's going to want to look at? They're going to want to see the job description. So the insurance company is going to want to say, what are the essential functions of this person's job? And you're not going to just, as the insurance company's on the phone, start making a list of what you think the essential functions might be. You want to pull out from your computer or, your file, the job duties, scan and email it to the insurance company, and that's it. So it's very effective and necessary for things like workers' comp. Same thing with short-term disability. And then if someone's been on a sick leave and we want them to come back, but we want their doctor to say, yes, they can perform their essential functions. How can the doctor just write a note saying, yes, they can perform their essential functions? What you need to do is have your employees send the doctor their job description. And then you can find out from the doctor the straight scoop, whether he or she believes that the patient employee can perform the essential functions. So job descriptions are extremely important, whether you have 6 or 60 employees.
What other documents should the business have in addition to job description?
Well, basic policies, for example, anti-harassment. That's required in Massachusetts. You must have anti-sexual harassment policies. It's probably one of the few things that's mandated. So that's again, Chapter 151B. It applies to employers with 6 or more employees must have anti-harassment policies. And also other policies that apply to employers, letting your people know whether they're hourly or salary, exempt or non-exempt, classifications of employees. That's important to put in your policy in case, again, there's ever an audit and someone needs to know, is this person hourly or salary, and or have they been entitled to overtime and not getting it? So policies like that, dress code policies, hygiene policies, those are not mandated the way the anti-harassment ones are, but very important. And when you go to do a restructure or a termination or a layoff of any kind, or you're combining jobs or reducing a part-time, a full-time to part-time, you're going to want to have policies that talk about what the necessities are, what you're considering, what are the factors you're considering in making these decisions. Policies also come into play when people are asking about how much PTO they have. So at time of termination, if you don't have a policy showing vacation accrual or how PTO is accrued, if you don't have a written policy and it's just like understood that, oh, we give 2-3 weeks, on the date of termination, you would owe that person 2 or 3 weeks, unless you have a policy showing that we only get PTO that's unused and accrued. So that's a pretty important policy to have anything to do with PTO, vacation time, sick time, and accrual. You do need a sick time policy. And Inmar mentioned, when you have fewer than 11, fewer than a dozen, or whatever, there is a difference in the sick time. One is paid if you have more than a certain number of employees. One is unpaid if you have less. But you still are required to have a policy, state law, the sick time policy, and that's that 1 hour for every 30 worked, protected time. So the policy would be for the very small employers, protected time. For the little larger employers, mid-sized employers, paid protected time. But that's another policy that employers should have.
Thank you. Something I see very often is that typically with smaller employees, but I've seen it with some bigger companies as well, that the business owners treat their employees as family. They over the years, they become really, really close, and they give them some flexibility. For instance, they'll allow them to work 30 hours 1 week, and another week they will work 45 hours or whatever to make up the difference, but there's no overtime. And everybody is happy because the employee gets the flexibility that they need or want. What can go wrong with a situation like this?
That's a really loaded question, Itamar.
No
Lots
kidding.
of things can go wrong. Lots of things can go wrong. Everything can go wrong. So we have Massachusetts Fair Wage and Hour Laws and the federal Fair Labor Standards Act. And that regulates, and wage and hour is a sensitive issue. These are dangerous issues for employers, small or large. And wage and hour laws apply if you have 2 employees. So don't think if you're below 11 or 15 or some of the other random numbers that are used for certain statutes that you're safe. And it's like a family team and we can just do what we like and we want to make it comfortable for our employees and not track their hours and not have them punching time cards. That's not the case. The smallest of small employers are required to abide by wage and hour laws. So in your scenario, you said something about 20 or 30 hours 1 week or more than 40 another, I think, and you cannot average hours. So the overtime law for hourly employees, so I think I have to answer a few questions within your question, perhaps. For hourly employees, it's 40 hours in a given work week, not a payroll period, a given work week. So if anyone works more than 40 hours in a given work week and they're an hourly worker, that kicks off the overtime. Now, for the weeks they only work 30 or 32, they get paid for every hour, every minute they work, which is the 32 hours or the 30 hours, whatever they've worked. But you can't combine them to say, oh, it's only 70 hours, no overtime, because it would be 80 hours for 2 weeks. No, it's a given work week and it doesn't go by payroll. Now, with salary employees, so those are those exempt, non-exempt are hourly, exempt are salary. And there's different categories of exempt employees and how they become exempt. So I could give a separate seminar on that. So with salary employees, there is more flexibility. And the difference being that if you're paying someone the same amount of money each and every week, they're getting their $1,200 a week salary, minus taxes and deductions or whatever, then we feel that they have some discretion, not total discretion. They have some discretion to say, I got this project done, I worked smart, I got a hold of the right customers, I was able to wrap up the deal. It was 38 hours, they get paid their salary. If it took the following week, if it took the salaried employee 42 hours, they had a bigger project, They weren't getting answers from the manufacturers, so it took a few extra hours. They still get their salary for that week. So that's what we feel about more executive, high-end administrative employees with managerial and discretion. We do have that flex of giving them their salary, as long as they're properly classified. Now, the other thing I've seen, it's not only, Inmar makes a good point with the, 30 hours, 40 hours and averaging, and we'll just give you whatever. I've seen a lot of the volunteer employee. So clients will tell me, well, no, it's okay, Helene. Don't worry. She volunteered to stay late. And she had no problem with it. She insisted. I said, please go home. It's 5:30, it's 6 o'clock. No. I want to finish up. I'll feel better. I'll start fresh tomorrow morning. Don't worry about it. Don't pay me. And I'll just stay here and wrap up. And, it's 7 o'clock, 7:30, and that person was wrapping up. Or I actually was personally involved in a case. Wow, it was many years ago. So I'm practicing a long time. So I think it was 1988 in federal court, where an employee used to go in on Saturdays. And she put in quite a full morning, maybe 8 to 12 or 8 to 1 even. And there was no time clock and she didn't punch anything. And there was no record of her working those hours, but everybody knew she was there. It was with a major hospital. And so small and mid-sized employers think they have all the problems because, the big corporations, they know what they're doing and they have all these people and they have in-house HR attorneys and they have other people and they have, personnel departments and they have payroll departments, but things slip through the cracks. And she would go in every Saturday and she was happy at the time. But then there was a falling out. And then she decided, you talk to a neighbor, you talk to someone in your family, talk to people in other businesses, and they say, you should be paid for all those Saturdays. And she said, yeah, I guess I should. And then at the time in the 80s, they'd say, because they didn't pay you, you'll get double damage. Oh, I think I'll go after that. So the problem with this team family approach of we just, we're small, it's okay. They can come in on a Saturday, they can stay late. You can work 30 hours one week, 40 hours another. That's great when the family's all speaking to one another and they're all happy and everything's hunky-dory. But if there's a change and somebody gets upset, or somebody's angry with somebody, or somebody's terminated, or somebody quits, all of a sudden, the people that were working 42 hours all those years might bring an action. And so that's I think, a really common problem. And another issue related to that is when the small employer says, well, we're a team, we're a family. My guy here, he wants to be an independent contractor. So that's cool with me. He doesn't want the taxes taken out and I'm thrilled I don't have to give him benefits. So we're like a family. We're just so small. We'll just call him an independent contractor. Big trouble. Everything can go wrong. Your question was, what could go wrong? Everything can go wrong. So it's wonderful to have this family bonding team approach. I'm not the Wicked Witch. I want small employers to have that feeling. But when it comes to things like wage and hour, where there's regulation, or contractors and employees, definition, classification, it can't play it so family loose and, we'll just do what the employee wants. We like our employees to be happy, but we can't violate the law.
So that leads to the next question. So what are the consequences of not following HR laws?
Well, it depends which one. So if you don't follow the laws I started with about discrimination, about if you have ads postings for your jobs that are discriminatory, and or you treat people differently based on any of the protected categories in mass law or federal law. Discrimination penalties at the Commission Against Discrimination where I worked would be damages awarded if somebody is successful in suing their employer. And again, discrimination laws do apply to small employers, 6 or more employees. And the damages could be back wages, even for an applicant. You know, if they get to the commission a year after they were supposed to be hired, certainly one of the hearing officers could think that they're owed a year of wage because you hired somebody else and it was discriminatory. So back wages, and that could be pretty significant depending on what the person was supposed to have earned. Emotional distress. Employers can be hit with emotional distress. I had cases where the damages and back wage were maybe $8,000 or something like that. But the hearing officer could award $50,000 in emotional distress or more. There's actually nothing in the employment law, by the way, that talks about the amount of the emotional distress. So it just depends on the case law. So a small employer that might have discriminated intentionally or not, we don't look at intent, could be subject to paying $8,000 in back wage, $50,000, let's say, in emotional distress, $58,000, and then the costs and attorney's fees for the employee that was suing them. The emotional distress could be $100,000. The back wage could be 20-something thousand. Needless to say, we're talking about big money for violating that particular law. For wage and hour, I think I mentioned, you know, someone goes and reports the employer, and if there's unpaid wage, be it overtime or the misclassification situation where someone's really got a bigger case because they've been treated as an independent contractor and they did not get all the monies and benefits they were supposed to. So unpaid wage is now, unlike 1988 or 1990, or whenever my case was, unpaid wage is subject to treble damage. I think I need a little water. Treble damage. So if you add up, if somebody was working 42 hours or 45 hours over the past 2 years, and then all of a sudden they're entitled to all of those hours at time and a half, and then they tell a former coworker, by the way, the Attorney General said if there's any other employees, we could bring a class action. You have 2 years of back wage of premium pay times 3 times number of employees plus penalties from the Commonwealth per violation.
What about the misclassification of a 1099?
Yeah, that's really problematic, and they will go in, they will audit your books, they will look to see what this contractor is doing that is so different than your employees. If it's not, if it's just the same old as every other employee there, and it's not someone coming in doing something totally unrelated to the business, that misclassification will lead to penalties and fines and anything else that you owe the misclassified person.
To clarify, 1099 is as a contractor, somebody who is not an employee.
Right.
Sorry.
So yeah, and the 1099, there's oh, and I forgot, in addition to the state coming in and the employee's right of action, the IRS gets involved with misclassifications of independent contractors and employees. So it's quite the whammy. the US Supreme Court actually has gotten involved, and there's like 15, 17 factors that we look at in determining whether someone's an employee or should be a 1099 contractor. There is a presumption in the law that we start out with the concept that someone's normally going to be an employee. And the US Supreme Court narrowed down and picked 7 factors. Most of you are familiar with the direction and control factor, so that if someone's under your direct control, they would be an employee. But there's so much more than that. There's just so much more than that that's involved in assessing whether someone's an employee or an independent contractor. I have clients, and I've remedied this and we've fixed it up, but clients who inappropriately had classified someone as an independent contractor, and then they paid them regular payroll each week with their other employees. Well, that's a big red flag if you get an audit from Fair Wage and Hour Division of the Attorney General's office. Yeah, I just also wanted to point out, for those of you who don't know, the Fair Wage and Hour Division in Massachusetts is part of the Attorney General's office. So that's a big red flag. The idea of being an independent contractor means independent. It's someone like my bookkeeper who comes in once a month, and she may be the bookkeeper for a few people on the screen. And she's an independent contractor. Yes, she comes in and she uses my conference room. Okay. And she may use one of my extra laptops. Fine. So, because one thing we look at is someone using your facilities, your equipment. But in this case, those are minor factors in the assessment. So the fact that she's using my laptop and my conference table, that's about it. She comes when she wants. She has many other clients. She books them as she sees fit. She accepts me or other attorneys or other people as she determines. She's in control of her own business. She has her own letterhead. She has her own phone number. So even though she uses my laptop and my conference room, the factors that support her being an independent contractor far outweigh the factors of employment. These should be weighed by a professional, by the way. Don't try to figure out on your own how to classify someone. So that's definitely something that could get small employers into trouble.
Quick question, just curiosity. Do you see that businesses are still following COVID protocols? What are you seeing out there?
Yes, and they need to revisit. They need to revisit. So in terms of a client I have that provides adult day hab, the rules are still that they must wear masks. So there are separate rules for certain professions, right? But in general business settings, my clients are not requiring masking. And that is now an individual decision by the business, unless, as I said, there's numerous exceptions. Some, of course, in the medical field, others in the care, like adult day habs and certain daycares. I know many of the daycares have disbanded the mask rule as well. The testing is totally different in terms of if someone's been symptom-free for a period of time, has no fever for 24 hours, shows that they're getting better and they're not developing new symptoms and that their original symptoms have abated, they can return to work. It doesn't have to be 10 days and 14 days and all like that. So we are revising everyone's COVID policies. You can still choose to do something stricter than the CDC is requiring. Now, your employees, some of whom don't want stricter regulations, may be pretty upset. So if your goal is to be able to attract and retain your good employees, and you know you're going to lose them if you have far stricter protocols than is now required, that's a decision your business has to make. And I have many clients who say, you know what? There was a big uptick over the summer, and I had employees out sick much of July, much of August. My family was sick. My friends were sick. I'm sorry, I can't run my factory this way. I did have one client say, I can't do this, Helene. I'm going back. I'm going back to the mask. I'm going back to physical distancing. He even had like staggered crews so that there were less people at one time in the back area. He's being extremely careful and kind, because he was trying to keep people well. But also, if you have a small business and half your people are out sick, how does your business survive? And if your business isn't surviving, how can you keep everybody employed? So it's a vicious cycle. So yes, people are relaxing protocols, and then I have people going back to reinstating some stricter ones. But the CDC is very much has loosened up their guidelines. Keep in mind, CDC are guidelines. They say that all over the place. They're guidelines. They tell us what they believe should be done, and people hang on their every word, but they are not, in terms of small employers, they are not, God's word, and you can do what you really believe is safest and best. Employers under OSHA, pre-COVID, have always been responsible for the safety and health of their employees. And we think of OSHA as, chemical spills at the workplace or broken steps, but OSHA relates to COVID and contagious diseases as well.
There's a question here from the audience. If somebody is working 3 to 5 hours a week as a bookkeeper, but they don't have other clients, should they be classified as employees?
I'd want to talk further to the person asking the question. I will say generally, they could be a part-time employee. If bookkeeping is part of the general operations of the business, if there's no one else doing financials at the business, and this is just the one person that's coming in on their own, are they setting those 3 to 5 hours? Are they choosing what day and what time? Are they billing the business for those 3 to 5 hours? See, there are many factors. So it's possible that a person coming in for a few hours a week to do tasks could be an independent contractor. It's also possible they could be a part-time employee, even if they don't have any other employers or any other people with whom they have contracts. So it will depend on other factors and whether they make themselves available publicly as A1 bookkeeping, or whether they're open to taking on other business. And who's directing and controlling them? Are they totally coming in, doing their own thing and leaving? Or is someone supervising? Is the account manager working with them? There's some more pieces to that puzzle, so I can't give a definitive answer, but it could be that they're a part-time employee, and I won't know without some more information.
Okay, fair enough. I want to switch gears now to annual reviews. Businesses are required to give their employees feedback on performance and so on and so forth. And sometimes a very daunting process. If a business doesn't feel like documenting it and going through the writing process, if you will, how should they document it? What is there a way to avoid the documentation? That's my question.
Okay, so in HR, in real estate, the mantra is location, location, location. But in HR, the mantra is documentation, documentation, and documentation. So I would never advise my clients to avoid documentation, but it doesn't have to be this onerous form, special boxes and colorful sheets of paper and the corporate heading on it and so forth. You can document in this day and age, much more so than decades ago, you can document really easily. For example, if you have some concerns, you were watching one of your inside salespeople and they were handling an account and they were saying something that you felt wasn't necessarily appropriate or wasn't in the best interest of your business, the way they answered the question from the customer or the way they followed up or didn't follow up. So you want to give some immediate feedback because that's important to your business and you don't want them to continue to do that. So you say, hey, Janie, can I speak with you a moment? And you speak with Janie and you say, you're doing a great job. Your numbers are good, but I have to tell you that what I just heard you say, that's not really what we're doing with the XYZ product. We're looking to sell those in bulk. The answer you gave the customer implied that maybe we were willing to do smaller supplies. So please remember, in that case, we're looking to do bulk. We don't want to use this kind of carton and this and that. And that's, I'm surprised because we had discussed that at last week's staff meeting. So please remember to do that. Okay, and they agree. Now you've had this lovely chat. It's been quick, it's been effective. She agrees, but you don't have documentation. And then you think, oh, Helene always wants me to have documentation. I have to go back to my office, find some form or call her and get a form. And what do I put? And now I'm wasting a lot of time. You don't have to do that. You can document by sending Janie an email. Good talk this morning. As I indicated, very pleased with your numbers this month. Just as you recall, I brought to your attention the issue with the XYZ company, the product. Again, please, we agreed that now not to go with smaller amounts. We're looking to sell that in bulk. Thanks for your time. And I know you'll remedy this in the future. Could even be shorter than that. It's a quick email, kind of self-serving, but you'll notice that you're just documenting the fact you chatted about it, you made her aware of it, and that you talked to her about it. So everybody's on the same page, and it's fair to her. It's like a little reminder, here's what we talked about. If it happens again in the future, you have your documentation. Wow, we talked about that August 13th. Remember? And she'll say, no. And I sent you a follow-up email on that. So I know I spoke to you about that on October 13th. And so, now I'm concerned. Why aren't you addressing this? Documentation can be just as simple as a follow-up email. And I love the idea of regular input. For example, the way I expressed calling over the employee, I also said something positive. For example, their numbers were good that month. It's very demoralizing for an employee to always hear only when they've done something that's not to your liking. So I would suggest respectfully that even if you don't have anything to criticize an employee about, you might want to give a, you go and kind of, wasn't that a great conference you had, or didn't that work out well, or wow, your numbers are up, good job, as you pass them by, because that's just as important. And you can say that in an email as well. I saw you talking to this customer, and when I joined you, I was bowled over. What a great manner you had. Customer clearly liked you, great rapport, good job. Takes 2 seconds to type that email. And this way, somebody got something in writing from you. So be consistent. Now, as much as I think this is great to have these quick, informal chats, again, you're not wasting a lot of your business time. It's just a few minutes. Then you get on the computer, you type the email, 2 lines, just a minute or 2. You still need that big performance review each year, because that is going to be comprehensive. It's going to be usually the manner in which you determine whether you're raising someone's hourly or salary compensation. It might be the way you determine whether you're giving someone a bonus. So a comprehensive yearly eval is important. Key to that is that you may unfortunately need to look at these performance reviews, the very detailed ones, for purposes of restructure, elimination of jobs, or termination for poor performance. So those are important documents, that one big one. Now, it doesn't have to be November, December, especially December. So many clients over the years have said, I realize you're right. I have to do the big performance review in December. I need to figure out their raise for January. I need to figure out their holiday bonus for December. But I'm always so stressed in December. It's just such a hard month. Everything's, we're trying to wrap everything up. And what I say is December is not a magic month. It's a nice month. My birthday's in December, so I think it's a pretty good month. But you can do the big eval in September or October. One of my clients on his own decided to begin doing it in October. And it's been a big relief for him, because by the time he gets to December, he knows exactly what he wants to budget for raises for January. And it's much easier to work with the payroll department or outside payroll service for December to issue bonuses. And so October is a fine month to do a big formal review. So performance reviews are important to have documentation. And then it's a good defense mechanism for business liability. So if you do terminate someone for poor performance, and they do go to some place like the Commission Against Discrimination, and they say, I know I was terminated because I'm 65. And you then send your response to the Commission Against Discrimination, and you say, I've received the claim from you, the charge of discrimination of my former employee, and the age couldn't have been less relevant to me. We have 10 other employees in their 60s, but Mr. John Johnson was terminated for poor performance, and solely for poor performance, nothing to do with his age. And what do you think the Commission Against Discrimination is going to be interested in seeing?
Paperwork.
Right. And what's going to show the poor performance, the big performance review that you did October or November or December, if you want. And of course, the little emails, maybe about not really handling the bulk orders right, or the inventory, or the client customer conversation right. But they're going to want to see something. Otherwise, this guy's saying, I had great performance. It's just because I'm old. And you're saying, no, it's just poor performance. So the deal breaker there, and it's going to lead to your protection as a business, is to have something showing his poor performance. Now, I really don't abide by blindsiding people. So keep in mind that if from January to September, you have not made any mention to Mr. John Johnson that there was anything wrong with his performance, that you were not displeased in any way with anything he was saying to customers or how he was handling the bulk orders and the shipping, then to hit him with this massive performance review in October or November and terminate him for completely unsatisfactory performance for the year, it's not the way to run your company. It's not the way to run your business. Other employees will be demoralized. And you're going to have a morale problem of those who are staying because they're like, why'd they get rid of him? Or he always thought he was doing a good job and we didn't want to, we're colleagues. We didn't want to say, hey, Joe, you're really not doing a good job. So it affects everyone and it puts you in a terrible liability situation and it doesn't look credible. If I was still at the MCAD and I was hearing that case, I was saying, gee, that really looks suspect. I'd say that smells fishy. They didn't tell the guy anything was wrong with his performance all year. And then all of a sudden it's the end of the year. You're a terrible performer. You're out of here. And oh, he does happen to be one of the oldest ones. Or he recently had a health problem. It looks very fishy. So be honest with people year long, both in making your criticisms, but also, tell them when they're doing great stuff too. That's how to retain good people as well.
We have a few more minutes. I would like to open it for the audience if there's any questions that you would like to ask Helene.
I don't know if there was something I have something in the chat. I'm not sure.
Yeah, I asked that question already.
Okay, you asked the chat questions.
Yeah.
You asked the chat questions.
No question?
I can add some tidbits. I talked before about handbooks. You may want to put in things about bereavement. Otherwise, everybody's throwing their hands up in the air. The managers are like, do we have a bereavement policy? Are we supposed to give this day off? Do we pay them for 1 day? Do we give them off for 3? The funeral's out of state. What do we do? Everybody's going, I don't know. Do we have a policy? Is there a law? So having something like that in the policy is a good idea. And the other thing I wanted to bring up was dress code. It's very hard, again, to give someone a warning or negative documentation about their manner of dress if you haven't at least let them know what your expectation is. It doesn't have to be a code, but just saying business casual maybe isn't clear enough to people. If you say no jeans or jeans only on Fridays, it's helpful to people. They can know what to buy and they know what your company's about. That helps with interviewing too. If someone feels it's arduous for them to wear black shirts every day with khakis, if that's your requirement, many restaurants have that. Or if you provide a lab coat and everybody has to wear the lab coat over their clothing, that might attract people. They're like, this is great. I don't have to worry about my clothes and they're going to give me a lab coat to wear. But those are the kinds of things to put in the manual. And also you can talk about that at interviewing it. Some things might be of interest to people and might get you a candidate just based on, we give bereavement leave, we give uniforms, we give lab coats, our dress code's fairly liberal, but you don't want liberal to be really torn up jeans, cut up things, short things. So you want to be clear in your handbook about these things, but those are other things you can add.
Yeah. Well, we're running out of time, so first of all, thank you for being here today. Very informative. Sorry, Valerie, you have any closing remarks?
No, I just want to say join today if you're not a chamber member. I'm going to be sending out some information to the attendees and hope to see you soon. We do have a business after hours tonight at Loon Pond Lodge, 5 to 7 p.m. Please come and join. We have a huge expo. How many people? 33, 34 tables of vendors and our members. So it'll be
36.
36. Oh my God, keeps growing. So please join and come on and see us tonight.
And if you, I am recording this, so I can send it to all of you if you are interested, once it downloads.
Pam, there's somebody here wants Helene's contact information.
Yep. I saw that. I will
you
get
have it,
that.
right? You have it,
I will
right?
send that with the video or the audio.
Okay, excellent.
Great.
Well,
Helene,
thank-
thank you so much. What a great
Yes.
such a wonderful overview and just reminding us to keep our T's crossed and our I's dotted when it comes to human resources.
Thank
Great.
you. It was a great information. Thank you. Thank you, everybody.
Thanks, everybody.